Yes, Mr. Prosser.
Good morning. I appear with David Yates KC for BlackRock Holdco 5 LLC, which I'll call LLC 5. David Ewart KC and soon to be KC Sadia Chowdhury appear for HMRC. May I first of all explain the factual background, what the substantive issues are, and also mention a procedural issue. In terms of factual background, as you may know, there are 3 Delaware LLC companies involved in the transactions, and I will, if I may, just call them the taxpayer company LLC 5, and then also LLC 4 and LLC 6. On the 1st of December 2009, LLC 5 entered into an agreement with LLC 4, whereby LLC 5 issued shares and 4 billion nominal of loan notes to LLC 4. And in return, LLC 5 received consideration of $10.6 billion, consisting of $2.1 billion of cash and $8.5 billion worth of shares in the parent company of the BlackRock Group, BlackRock Inc., BRI.
Mr. Prosser,
Yes.
I seem to have an extra screen. Are we having a transcript? Or is there a transcript? Or do we know what the screen is?
I'm not aware of what the screen is for, I'm sorry, no. Do we have a transcript? I understand we do have a transcript, but it's not. But it's not live note.
It's not live note, so I can ignore the screen. But at any rate, it means I don't need to take quite as full a note, and I can listen more carefully.
Thank you.
Yes, thank you.
So LLC 5 has received $10.6 billion worth of cash and BRI shares, and in return has issued shares of its own and also these $4 billion of loan notes. LLC 5 then paid that $2.1 billion of cash and the BRI shares to LLC 6 in return for LLC 6 preference shares, 2.4 million preference shares. At the same time, LLC 4 paid LLC 6 $107 million cash in return for the issue of 100,000 common or ordinary shares in LLC 6. And those common or ordinary shares gave LLC 4 voting control of LLC 6. And then the final step, LLC 6 in turn used the 2.2 billion now of cash, the 2.1 received from LLC 5 and the 100 odd received from LLC 4, and the BRI shares to acquire the US investment management business of a Barclays Bank PLC subsidiary, Barclays Global Investors, BGI or BGI US, by acquiring the shares in the target company, a company called Delaware Holdings Inc., from Barclays Bank PLC. Now, as I've explained, LLC 5's only asset was the preference shares in LLC 6. And it could only meet its obligations under the $4 billion nominal of loan notes which it had issued to LLC 4 out of dividends on those preference shares. Now, in legal terms, although the preference shares carried a prior right to annual dividends of $720 million, with the common shares thereafter carrying the right to the next $2 million of dividends, so that LLC 5 would be entitled to 99%, whether dividends were actually paid or not was at the discretion of LLC 6's directors, and as I've mentioned, voting control over LLC 6, and therefore control over the composition of LLC 6's board, was vested in LLC 4 and not LLC 5. So LLC 5 has got these preference shares, which on the face of it, in terms of a dividend flow, if there is any, are very valuable, but it can't control that dividend flow. Now that was the legal position.
Do we have any explanation of why the quantum of the loan notes was $4 billion, which was more than the cash received?
Well, it was more than the cash received, but much less than the overall consideration received by LLC 5, because it also received, as I've mentioned,
Yes, 8.5 billion of shares.
8.5 billion worth of shares. It was simply a package that was required by the group to acquire BGI US, and LLC5 was one of the vehicles in the chain to acquire that package of consideration and pass it on to LLC6, which then used it to make the external acquisition. But I don't have any understanding or explanation as to why
the figure was 4 billion rather than say 3 billion or 5 billion.
Okay, well,
the evidence doesn't explain that.
Right, it doesn't, and maybe, and I'm speculating here, but I think the answer may be that for tax purposes, in order to be able to get a deduction for interest, you have to make sure that the company in question is not, as it were, thinly capitalized, that it has a certain amount of equity to support its debt.
I may be misrecalling, but I thought there was some backing transfer pricing analysis that was produced before the transactions were entered into.
There was.
That may cast light on this.
I think that transfer pricing analysis was also, in effect, including the thin capitalization analysis.
Which is based on my point.
Yes.
So it's not a purely arbitrary figure. It's a figure carefully calculated to come within the thin capitalization regime.
Yes.
Yes. Thank you.
Now, I've mentioned the legal position in terms of the rights attaching to the preference shares in LLC 6, but there was an informal understanding between LLC 5 and the other members of the BlackRock group that sufficient dividends would in fact be paid to enable LLC 5 to meet its obligations under the loan notes.
That reference to informal understanding, is it reflected in a finding in the FTT decision?
No, and I will in a moment to explain why that is.
Thank you.
In the light of that understanding, the LLC board felt it was able to decide that it was in LLC 5's commercial interests to issue the loan notes. But clearly, if you've issued, I should have mentioned these loan notes are interest bearing, obviously, and I can take you to the terms. The FTT sets out there were 4 tranches of loan notes, what the rates of interest were, that interest was payable annually. Clearly, LLC 5 could not safely enter into an obligation, or those obligations to pay interest, and these loan notes were also redeemable over the next 10 years or so, when all it had legally was the right to these preference shares, which didn't give it any ability to obtain the dividends. But in the light of the understanding that I've mentioned, the LLC 5 board felt that the deal made commercial sense, and they decided to enter into those transactions.
Do we assume that the obligations of directors of the Delaware LLC are similar to the obligations of directors of an English company?
There's no evidence to the contrary. Yes. Now, if I then may turn with that brief snapshot, as it were, of the facts to the substantive issues. HMRC, I beg your pardon.
Could I just confirm my understanding in relation to the timetable? You very kindly and helpfully provided us with a timetable, which we're happy to let you get on with, but it provides for the hearing to have ended by midday, the midday adjournment on Thursday.
And we know that you've got something else to do.
Well, I'm afraid on the basis of that, yes. So Thursday afternoon has now, so far as you're concerned, gone, but I don't think that's going to cause you any
We don't believe so, no.
difficulty. No, thank you for that.
So HMRC contend that LLC 5 is not entitled to a tax deduction for the interest paid on those loan notes to LLC 4 for 2 separate reasons. First, because the deduction is precluded by the transfer pricing provisions in Part 4 of the Taxation, International and Other Provisions Act 2010, TIOPA. Those provisions apply to a transaction between associated enterprises, such as those between LLC 4 and LLC 5, and require one to ask what amount, if any, and on what terms, would LLC 5 have borrowed from an independent enterprise, an independent person, one which had no shareholding in LLC 5. Now, HMRC's case, as set out in their statement of case, and as argued before the FTT, and as recorded at paragraph 92 of the FTT's decision, was simply that the loans would not have been made if LLC4 and LLC5 had been independent enterprises.
Sorry, was it para 92?
92.
Thank you.
That is, HMRC argued, first, that an independent lender would not have made any loan to LLC5, given that LLC5's only asset was the preference shares, at least not without a parent guarantee, which, as we'll see, you're not allowed to postulate in the arm's length transaction. Secondly, HMRC argued that the BlackRock Group would not have allowed LLC5 to enter into any loan with an independent lender, because that would have been costly and complex, and it commercially irrational, given the obvious alternative of another member of the BlackRock Group borrowing, such as LLC6 or indeed BR Inc. itself. Now, the FTT rejected both of those arguments by HMRC. First, it held on the basis of the expert evidence that an independent lender would have been willing to lend to LLC5 with the addition of third-party covenants, intercompany covenants, to secure that the dividend flow would take place and would not be somehow diverted. I will come on and explain exactly what those covenants were, but that was a summary of what the FTT decided. And the independent lender would have done so, and willing to do so, without a parent company guarantee. Secondly, the FTT held that the transfer pricing legislation does not permit one to adopt, as it were, a group point of view, so that the objection on HMRC's part that the BlackRock Group would not have permitted LLC5 to borrow was a bad one. I mean, if that argument were a good one, virtually no subsidiary would ever be able to get a deduction, because it would always be said, well, it makes more sense for the group to borrow where there are more assets at the stage of the parent company. I don't think that group point of view argument is being maintained by HMRC. Now, the important point is it was no part of HMRC's case, whether in their statement of case before the FTT hearing, or in their FTT skeleton, or at the FTT hearing itself, that quite apart from the arguments which HMRC were running, as I've summarised, the transfer pricing legislation does not permit one to postulate the addition as part of the arm's length transaction of third-party covenants, because that would involve altering the economic characteristics of the actual transaction. That was no part of their argument before the FTT. Now, because HMRC didn't run that argument, the FTT didn't discuss it in its decision or make any findings of fact about the economic characteristics of the actual transaction. In particular, we didn't invite the FTT to make any findings about the informal understanding I mentioned a few minutes ago, even though there was undisputed evidence of it. However, HMRC having lost before the FTT, they did advance that argument that you're not permitted to postulate third-party covenants because they would alter the economic characteristics of the actual transaction before the Upper Tribunal. And paragraph 47 of its decision, the Upper Tribunal acknowledges that there were new arguments on HMRC's part before it. The Upper Tribunal also says we didn't object to that new argument being run. And that's correct. We didn't object to it being run in the Upper Tribunal because, as I've mentioned, there was undisputed evidence of the understanding, and there was no further evidence which could have been adduced before the FTT in relation to the new argument. So it's not as if we could have said, well, if we'd known about that new argument, we would have produced further evidence. We had the evidence that we wanted. It was undisputed. Now, at the Upper Tribunal hearing, we, on our side, referred on a number of occasions to the understanding and to the evidence that I'm going to take you to. And HMRC didn't say, well, there are no findings of fact by the FTT about that. If HMRC had said that, if they'd objected to us referring to and relying on the evidence, we would certainly at that point have objected to running this new argument. Now, in the event, the Upper Tribunal...
They can't have it both ways.
Well, exactly, that's my submission. Now, the Upper Tribunal has recorded at paragraph 59 of its decision, it decided, in agreement with HMRC, that importing third-party covenants into a hypothetical transaction that didn't exist in the actual transaction both changes the substance of the transaction and the economically relevant characteristics of the actual transaction, which you're not allowed to do, and therefore the FTT had erred in law in its transfer pricing decision. Now, we submit in the appeal to this court that the FTT, the Upper Tribunal, thereby erred in law. Now, in our skeleton argument for this court, we refer to and rely upon the informal understanding that I've mentioned and the undisputed evidence of it. But now, for the first time, in their skeleton argument for this court, HMRC are questioning whether there was any such understanding and are saying that the FTT made no findings about it and that we didn't contend before the FTT that there was any such understanding. Now, I've explained why we didn't, why the FTT didn't make any findings and why we didn't contend for any findings. Now, I respectfully submit, perhaps I should just, in case there's any doubt about it, take you to a couple of paragraphs of HMRC skeleton where they are saying, first of all, they're questioning whether there was any such understanding. This is paragraph 10 of their skeleton for this court, which you'll find in the core bundle, tab 4. And I can do this very quickly. In paragraph 10, on page 4 of the skeleton, page 60 of the bundle, at the very top, there's a sentence beginning, insofar as there was such an understanding, which, as I see it, doesn't accept that there was any such understanding. And then at paragraph 11, it begins, there are no findings of fact that the covenants did exist, although informally. And perhaps if I can take you to paragraph 20, where this point is made again, on page 62, page 6 of the skeleton. Paragraph 20 says, LLC 5 states there was unchallenged evidence before the FTT that there was an understanding within the BlackRock Group that LLC 5 would in practice receive dividends on its preference shares so as to enable it to meet its obligations to LLC 4 and the loan notes. However, the FTT did not make any findings in respect to this evidence. Now, I won't bother with the rest of it. So those are the points that are now being made by HMRC, and we respectfully submit, as a matter of procedural fairness, HMRC should not be permitted to pursue their new argument, this argument about changing the economically relevant characteristics, except on the footing that we can refer to and rely on the undisputed evidence of this informal understanding, notwithstanding the absence of findings. And indeed, I would go further, unless HMRC accept that there was such an understanding based on the undisputed evidence. So that's my procedural submission based on fairness. Now, I think I need to take you to the undisputed evidence very briefly, which is summarised at paragraph 55 of our skeleton argument. Which is core bundle tab 2.
Yes, I'm sorry. Would you give that reference again?
Yeah. Core bundle tab 2, our skeleton argument, paragraph 55.
Thank you.
Sorry, just to clarify, going back to the transcript, I hope someone will make sure that we get copies at the end of each day.
Right, I will make sure that that is done. So paragraph 55 of our skeleton. There was unchallenged evidence before the FTT that there was an understanding within the BlackRock Group that LLC 5 would in practice receive dividends on its preference shares so as to enable it to meet its obligations to LLC 4 under the loan notes. That is, and then 1, Mr. Cushell, who was the chairman of the LLC 5 board and a member of BlackRock Group's Global Executive Committee, gave evidence in cross-examination that he felt quite comfortable that the dividend stream would be safe because it was the interests of LLC 4 which could not receive any dividends on its common shares unless and until LLC 5 had received its dividends, to ensure that LLC 5 was paid. And then just stopping there, in terms of the evidence about the board meeting, which Mr. Cushell was the chairman of, the board minutes, which you will find, I don't think I need to take them to you because you'll see it on the transcript. The board minutes, they're in the supplementary bundle, tab 17, and it's the bottom of page 319 of that page of the board minutes. 319 of the bundle, not 319 of the board minutes. The board minutes are quite short. Those board minutes record the board considering a Duff and Phelps analysis of the relative values of the common shares and the preference shares of LLC 6 based on a cash flow model with estimated discount rates applied to anticipated dividends.
Just to pause there, it was the Duff and Phelps analysis I was referring to earlier.
Right, okay, yes. Right.
Analysis.
Right. Okay. Now that cash flow model, which is at the supplementary bundle tab 16, the previous tab, page 317, sets out each year's anticipated dividends and that they would suffice to enable LLC 5 to meet its obligations under the loan notes. Now that was something specifically that the minutes record the board looking at. So my submission is that was clearly taken into account by the board, their anticipation of the receipt of those dividends every year as part of their decision making as to whether or not it made commercial sense for LLC 5 to enter into these transactions. So that's the first point. And then reading on in paragraph 55, Mr. Cushell also agreed with Mr. Hewitt that the people designing the transaction and who proposed it to the board had already factored into the transaction, as it had been set up, that there would be sufficient income to pay the interest on the loan notes. So it's not simply, as it were, LLC 5's assumption. Those structuring the transaction, designing the transaction, had themselves factored this in. Then the next point is Mr. Fleming, who was head of tax of the European and Middle East and so on part of the group, and a member of the corporate tax group, which devised the structure, gave evidence in cross-examination that we felt that LLC 5 was protected, but because LLC 4 had got no dividends until LLC 5 had received its dividends, and we would not have been concerned about LLC 4 acting capriciously or in any way detrimental to LLC 5 at the time. And Mr. Hewitt put to Mr. Fleming that BGI US's profits would obviously feed through to LLC 6 ultimately, and Mr. Fleming replied the assumption would have been taken for these purposes that essentially 100% of it would have made its way through. Then to the same effect, Mr. Hewitt asked, and the other assumptions that had been made, I think we discussed earlier, was that the dividends would have been paid, and despite the fact that a different company had control of LLC 6, that would happen. And that means paid to LLC 5, because he's referring to a different company having control of LLC 6. Yes, that was never in doubt. Mr. Hewitt said it was never in doubt, yes. So that's why we say it's undisputed, because Mr. Hewitt himself is making the point. It was never in doubt that these dividends would flow through. And then finally, there's a reference to HMRC's own expert and what he stated in his report. And that's significant as well, and I'd like to take you to that very briefly. This is tab 4 of the supplementary bundle. If I could take you to that. It's just a couple of paragraphs of his report, starting at paragraph 230. So this is Mr. Gaisford, who was HMRC's expert. Paragraph 230 of his report is in tab 4 of the supplementary bundle, page 93. And he says, in this specific case, in addition to the written loan contract, there are a number of other related contracts, and he gives examples, and understandings. For example, LLC 5 had no reason to doubt that LLC 6 would not pay it dividends. And then 231 he says, in other words, it seems appropriate to view the loan between LLC 4 and LLC 5 within the economic context of the overall structure. And then if we go on to paragraph 232, he says the nature of the relationships between LLC 4, 5 and 6 all have bearing on the degree of risk being taken on by LLC 4 when providing the loans to LLC 5. Risk is a major factor. Then he says the fact that these companies had and continue to be part of the same overall structure would suggest there was a degree of common understanding and implicit assumptions made by all parties regarding the relationship that goes well beyond the terms of the written loan contract. And then if we jump down to 236, he says that there are three ways we could look at the transaction. A, the narrow way is just looking at the loan agreement, the sort of legal position. Then there's a medium transaction with some extra bits, and then a wider transaction on page 95 that builds on the medium transaction by adding the support letter and covenants from elsewhere in the group to ensure the income and cost flows to LLC5 would be managed such it didn't fail. And then at 237 he says, he compares them, and then at the end he says the wider transaction is more in the spirit of taking account of all relevant information, in the sense that I believe it captures more completely the relevant economic characteristics and circumstances of the actual transaction. So that was HMRC's own expert saying, because of that understanding, then you factor that into the relevant economic characteristics of the actual transaction. So that was the undisputed evidence that we still rely upon. And as I say, we submit respectfully that HMRC should make a choice. They either abandon their new argument or they run it, but on those terms that I've mentioned. Now, HMRC may say, well, you should have run this point below. But as I've said, before the Upper Tribunal, there was no question of HMRC questioning the understanding or taking the point that there were no findings of fact by the FTT. In terms of, well, maybe I can just park that.
You say this is a new argument raised by the revenue in this court?
No, I'm not suggesting it's a new argument in this court. They argued in the Upper Tribunal that...
No, the point about the absence of findings.
Yes, I'm sorry, yes.
Is one they've raised in this court.
Yes.
And so what help me with this. If the FTT were right to take account of third-party covenants that might be required in an arm's length transaction, how much does this point matter?
To us,
yes.
In this case? Well, if they were entitled to take into account third-party covenants, then we win on the transfer pricing.
So you don't need this?
No, we do, because we needed, before the FTT, we needed a finding that an independent lender would lend if they got covenants. Then the question is one entitled to postulate such covenants? Mm-hmm. That is the dispute now. Mm-hmm. But in order to get home on that, we need to say that importing those covenants into the independent lender transaction does not materially alter the economically relevant characteristics of the actual transaction. In other words...
It may be legally different, but economically you're trying to get a comparable transaction, yes. And the only way to get what you say is a comparable transaction is to formalise what internally in the group is left informal.
Yes, exactly. That is exactly my point. So I do need to rely upon that informal understanding to show what the reality, the economic reality was in the actual transaction so far as risks were concerned. Risks, we know, is a very important part of the transfer pricing analysis. So the question is, was LLC5 really economically at risk of not receiving its dividends, such that the lender, LLC4, as a lender, was at risk of not being paid? The answer to that is no. You then say, right, let's stick with that reality when we look at the hypothetical transaction. And obviously, an independent lender would say, I'm sorry, I'm not prepared to make do with that informality. I want that formalised in terms of covenants to make sure that what you understand will happen, legally will happen. That's the only difference between the actual and the hypothetical.
Is there a finding of fact by the FTT that an independent lender would not lend without some covenant
Yes.
to protect the dividend flow?
Yes.
Yes.
They do say they would not lend on the actual terms, but they would lend with covenants.
So does that mean if you're wrong on this point, then one has to do the transfer pricing analysis on the basis that in the independent world, no loan would have taken place at all?
If I'm wrong in the sense that either that one says that the economic reality of the actual transaction was that LLC 4 and 5 were running these risks, then yes, I accept that you wouldn't be allowed to alter that economic reality by importing covenants. So, in a sense, the case turns on that point. In my
Well, can I? There's another way of approaching this that doesn't possibly depend on informal understandings, and I may come back to this because I don't think it's the way the case has been put by either side. The reality is, in the real world, LLC 4 controlled LLC 6.
Yep.
It controlled the Delaware holdings. It had full voting control
Yep.
to make sure these things happen. It
Yep.
doesn't need anyone else's
No.
understanding.
Right. Absolutely. Now, I ran that as an alternative argument before the FTT. I argued, let's assume that I'm wrong about an independent lender wanting and accepting covenants. I said, let's postulate that the independent lender also owns the common shares in LLC 6. And in those circumstances, the independent lender is not running the risk. Now, the objection to that was that there would be difficulties in postulating that from BlackRock Group's point of view. I mean, the starting point is, would the BlackRock Group, because after all, the shares in LLC 6 are the shares which control BGI US, this very valuable acquisition. Would they really be willing to let a third party, independent lender, have that voting control over LLC 6? Now, if the answer is, well, that's just a non-point, because you have to postulate it, come what may.
You see, I mean, just to pursue this,
Yeah.
you have to postulate an arm's length relationship between the borrower and the lender. We're talking about LLC 4 and LLC 5. At least in theory, you can postulate breaking the shareholding relationship between them, but not breaking other relationships, including LLC 4's control of LLC 6.
That was my argument below.
Okay.
Now, let me put it this way. If it is right that you necessarily have to read across the reality of the actual transaction apart only from the special relationship between the actual parties, LLC 4 and LLC 5. Everything else is a given. If that is correct, then, in my submission, despite the difficulties for the BlackRock Group of accepting that the voting shares in LLC 6 are now owned by a third party, that is nevertheless something you have to postulate in comparing the actual transaction with the hypothetical.
Well, it depends what your starting point is. You could LLC 4. All you're doing is breaking the shareholding relationship between LLC 4 and
Right.
LLC 5.
Yeah. Okay.
Anyway,
Right.
You raised it in the FTT.
I raised it in the
It
FTT.
just seems to me that it's a question I had to ask because I couldn't see where that point had gone.
No, well, it's certainly gone in the sense that we're not advanced. We didn't advance it. We lost it in the Upper Tribunal as well, but on the ground that.
Sorry, I haven't quite understood. What is the point that you advanced and lost?
We advanced the point that you could postulate in the hypothetical transaction that the independent lender owned the common shares in LLC6, as LLC4 in fact did.
Why do you advance? That's not part of a loan transaction.
Well, that was part of the objection to the point, that it wasn't part of the loan transaction. Nevertheless, the support for that argument is what you're supposed to do when you compare the actual with the hypothetical is assume that the parties to the actual transaction are not related, but that everything else in the real world is read across to the hypothetical world. And my argument was everything else includes the fact that the lender also owns the common shares in LLC6.
So there is support in the legislation for attributing the actual characteristics
Yes.
apart from the relationship. And the most obvious support is the provision in section 152 that says please ignore the fact that it's not part of the lender's business to make loans generally.
Yeah.
That suggests that you look at the actual characteristics.
I was going to make that.
Unless you're told otherwise.
I was going to make
Anyway,
that.
I wanted to raise it.
Well, just to be clear, I'm not suggesting that you should not decide that as a matter of law, you have to assume that LLC6, the independent lender has all of the attributes of the actual lender, including the common shares. If that as a matter of law is correct, then the objections which caused me to lose in that point in the Upper Tribunal fall away, because they were simply factual objections about the difficulties for BlackRock Group of accepting that an independent lender owned the common shares in LLC6 and therefore in this very valuable BGIS group. Those factual objections would fall away if, as a matter of law, you have to postulate that.
And then you wouldn't need third-party covenants.
Then you wouldn't need third-party covenants. Now, I would respectfully submit Mr. Ewart could hardly object to that because it doesn't raise any questions of fact. It's just a very short point of law about what you're forced to postulate.
But it's not part of your grounds of appeal.
No, it's not. I accept that.
Could we just identify such traces of this argument as are found in either of the two decisions below?
Yes.
I mean, I have at the moment open in front of me, as it happens, the UT at 104, 105, but it may not be touching on the same point.
So in the FTT...
Start with the FTT.
Yeah. Yeah. Sorry. So at paragraph 104
Yes.
of the FTT decision, which is page 39 of the decision and page 192 of the core bundle, the FTT says it's not necessary to address my alternative argument on the basis of an independent...
Sorry, where are you?
Paragraph 104,
Of the
192 of the core bundle.
wrong decision, sorry.
It's therefore not necessary to address the alternative argument advanced by Mr. Prosser on the basis of an independent third party, in addition to the loaning 4 billion, subscribing for common shares in LLC6.
Is that a reference back to something that has been said earlier in the decision?
Yes, and then I can find where that is. So this is paragraph I'm not sure it is. Does he refer to it? No, I think sorry, I apologise. I think actually he doesn't mention it earlier on at all.
All right.
Mr. Brooks, Judge Brooks.
Right, so it flashes through at 104 to
It flashes
105.
through. And the objection, he says at 105 that the experts weren't instructed to consider it, and that Mr. Gaisford said that there were problems with it, problems for the BlackRock Group. But my submission is that if you have to postulate it, you have to postulate it, whether there are those problems or not. And then in the Upper Tribunal, this starts on page 109, paragraph page 20 of the Upper Tribunal decision, paragraphs 96 onwards. It's headed the alternative co-investor approach. And it goes on to, well, paragraph 98. So it's not rejected on the grounds that, as a matter of law, you don't do it. It's more on the facts that there are problems with it, and there wasn't enough evidence about it. So that's obviously an alternative to my reliance on the understanding. Going back to the understanding point, Lady Justice Falk may remember a case called Altrad Services, where the Court of Appeal effectively put HMRC in that case to a choice. If you want to run this argument, it's on terms that certain facts are assumed. That's my submission. So I've identified the current issues, transfer pricing issues, except that HMRC appealed, when they appealed to the Upper Tribunal, they ran a number of other arguments, some sort of evidential and factual arguments, where it said the FTT had erred. The Upper Tribunal rejected all those arguments. HMRC maintained one of them in this court. Mr. Yates will address that one, if that's all right.
That Edwards and Bairstow one?
Effectively, it was an Edwards and Bairstow argument about the FTT having misunderstood the evidence of the experts. There's a different Edwards and Bairstow argument.
The experts one.
Yes. There was a different Edwards and Bairstow argument to do with the unallowable purposes issue, about the commercial purposes that the LLC5 board had. But yes, it is also an Edwards and Bairstow point. Now, so that summarises the transfer pricing issue. The alternative case for HMRC is that the deduction for the interest is precluded by the unallowable purposes provisions in sections 441 and 442 of the Corporation Tax Act 2009. They provide that if a company enters into a loan for an unallowable purpose as defined, including a main purpose of obtaining a tax advantage, then insofar as, on a just and reasonable apportionment, the interest paid on that loan is attributable to the unallowable purpose, it's not deductible. Now, in terms of summarising the FTT decision, the FTT held, first of all, in deciding what the purposes of a company are, first of all decided you must look at the purposes of the company in deciding whether the company has an unallowable purpose. Secondly, in deciding what the company's purposes were, the FTT said look at the purposes of the board, the subjective purposes of the board. Then the FTT went on and made findings of fact, which I'll take you to, which were that when LLC5, the board of LLC5 decided that the company should enter into these transactions, including the 4 billion loans, their only conscious subjective purpose was a commercial one of furthering the company's investment business. That they did not have a conscious subjective purpose of obtaining a tax advantage, because, following advice, they left that advantage out of account because the company could not benefit from it. And the reason the company couldn't benefit from the tax advantage was because it had no profits, taxable profits, to offset against them itself, and the policy of the group was that group relief surrenders should be for no payment. So LLC5 itself could not benefit. It was neutral as far as LLC5 was concerned, and the board decided, because it makes no difference to LLC5, we're going to leave that tax advantage out of account, and we're going to ask, in terms of other factors, whether it makes sense for LLC5 to borrow. And they said it does make sense, partly in the light of the understanding I've mentioned, and they decided, therefore, that LLC5 should borrow. Now, those are the facts the HMRC found about the conscious subjective purposes of the board, but the FTT went on and said it was necessary to look beyond the board's subjective purposes, because obtaining that tax advantage was an inevitable consequence of borrowing at interest. And the FGT thought that the decision in the House of Lords in Mallow and Drummond meant that an inevitable consequence must be a purpose, a subjective purpose. And the FGT said because this was clearly an important purpose, and therefore it was a main purpose of the board. So that's what it found about purposes, including a sort of Mallow and Drummond type purpose. And then applying the attribution test, the FGT held that the LLC board would have borrowed the $4 billion even in the absence of that tax purpose on the basis of evidence before it, and therefore it decided that none of the interest was attributable to that Mallow and Drummond unallowable purpose. So that's what the FGT decided. HMRC appealed to the Upper Tribunal on two alternative grounds. The first, that the FGT had erred in law on Edwards and Bairstow grounds in finding that the board had a commercial purpose for borrowing. The second was, it erred in holding that on a just and reasonable apportionment, none of the interest was attributable to the tax purpose. Now, importantly, HMRC did not appeal to the Upper Tribunal against the FGT's finding that the LLC5 board did not have a conscious subjective purpose of obtaining a tax advantage. There was no Edwards and Bairstow appeal to that finding of fact. Now, LLC5 served a respondent's notice arguing that the FGT had erred in law in finding that the board had a sort of an unconscious Mallow and Drummond type subjective purpose, because Mallow and Drummond simply had no part to play in relation to a legislative consequence like this. Now, the Upper Tribunal rejected HMRC's Edwards and Bairstow challenge to the finding of a commercial purpose, and also agreed with LLC5 that the FGT had gone wrong in finding this Mallow and Drummond type purpose. But the Upper Tribunal said the FGT hadn't erred in law in finding that LLC5 had a subjective purpose of obtaining a tax advantage, because it said in identifying the company's purposes, the FGT was entitled to look beyond the board's subjective purposes. And looking beyond meant looking at why the group decided to create LLC5 and insert it into the acquisition structure. And there was plenty of evidence that the reason for that was to get the tax deduction. So the Upper Tribunal's basis of allowing HMRC's appeal was that you look beyond the subjective purposes of the board to other purposes which you can attribute to the company, the purposes of the group, in creating the company and so on. And then the Upper Tribunal also held that the attribution test asks objectively why the debits, the interest, existed. It's nothing to do with the subjective test that we've so far looked at. And objectively, the only reason the debits existed, the only reason the company existed, was because of the group's purpose, tax purpose. So that the Upper Tribunal said the FGT had erred in applying the attribution test by reference to subjective purposes. Now, we're appealing against that decision of the Upper Tribunal. We submit that the Upper Tribunal erred in law in looking beyond the board's subjective purposes to some other purpose of the company that one could attribute to it by reference to the group's purpose. It wasn't as if the board was acting on instructions, so I will take you to the findings of the FGT about that. That isn't the reason why the Upper Tribunal said you could attribute the group's purpose to the board. It was simply, well, it was a sort of an anti-avoidance reasoning, really, that otherwise you'd be undermining the legislation. So that is my rather long summary, but hopefully relatively helpful of where we are, kind of thing. Could I then start by making my submissions on the transfer pricing issue, and to take you to the authorities bundle, volume 1, tab 5, which contains the domestic legislation. This is part 4 of TIOPA 2010. Now, I should explain, first of all, because it's the 2010 Act, it applies to accounting periods ending on or after the 1st of April 2010. In fact, LLC 5 was paying interest before then, because this slightly before then, only a short period before, when the predecessor legislation applied, but nothing turns on that difference. So everyone's content to refer to the 2010 Act.
That paragraph 13.
Are
we in that territory, or am I mixing that up?
Para 13 is the predecessor of sections 441 and 442. The predecessor of this is Schedule 28AA of ICTA 1988. I don't know whether my lord had experience of paragraph 13, but it's a good thing to have remembered. So we can look at this for all the accounting periods of LLC 5. Now, on page 29 of the bundle is section 147. If I can read subsection 1, for the purpose of this section, the basic precondition is that there are 4 preconditions. A, provision, the actual provision, has been made or imposed as between any 2 persons, the affected persons, by means of a transaction or series of transactions. B, the participation condition is met. Just to get that out of the way, it's common ground that the participation condition between LLC 4 and LLC 5 is met. C, the actual provision is not within subsection 7. Well, it's not. That's to do with all transactions, so that's common ground as well. D, the actual provision differs from the provision, the arm's length provision, which would have been made as between independent enterprises. So the debate revolves around A, what was the actual provision, and D, whether it differs from the arm's length provision, which would have been made. And then we're told subsection 2, subsection 3 applies if the basic precondition is met, so we're saying it's not, and B, the actual provision confers a potential advantage in relation to UK tax on one of the affected persons. We accept there would be an advantage in this case, so there's no doubt about that. Potential advantage is defined in section 155, but it's common ground that if the basic precondition is met, then subsection 2 applies, and therefore 3 applies. The profits and losses of the potentially advantaged person are to be calculated for tax purposes as if the arm's length provision had been made or imposed instead of the actual provision. And I can take you to the section in a minute, but we're also told, I think it's section 151, that the arm's length provision can include no provision at all. And it's HMRC's case that the arm's length provision would be no loans at all. And therefore, if you have to substitute the arm's length provision of no loans at all for the actual provision, then obviously there's no deduction for the interest. So that's all I need to read about 147. But it's very important, if we go back to subsection 1A, that its provision has been made or imposed between any 2 persons by means of a transaction or series of transactions. First of all, the reference to any 2 persons means any 2 persons, not 2 or more. And there's a case called DSG Retail, which is in the bundle, where the special commissioners, Dr. Avery Jones and Mr. now Tribunal Judge Hellier, decided that point, that 2 means 2. So in this case, we're looking at provision between LLC 4 and LLC 5. That's the only provision we're interested in. Now, HMRC had an argument about what you infer from that, only 2 persons, that means itself you can't postulate third-party covenants. I'll come back to that point. That's a bad point, but I'll come back to it. Now, still in A, the reference to a transaction or series of transactions if you go to section 150, on page 33, there's a definition of transaction and series of transactions. Subsection 1 of 150. In this part, transaction includes arrangements, understandings, and mutual practices, whether or not they are or intended to be legally enforceable. So one of our points is, well, there was an understanding between LLC 4 and LLC 5. And then references to a series of transactions include references to a number of transactions each entered into in pursuance of or in relation to the same arrangement. And then then we're told various things which don't really matter in subsection 3 and 4 about how wide the series can be. Now, before we leave, so we were looking at that for the purposes of 1471A. Can I then ask you to jump to section 164, which is on page 51, because this is also relevant to the interpretation of 1471A. So 164 is headed part to be interpreted in accordance with OECD principles. This part is to be read in such manner as best secures consistency between the effect given to sections 1471A, B and D. We're not interested in B, but D we are. We're not really interested in the others. And the effect which, in accordance with the transfer pricing guidelines, is to be given in cases where double taxation arrangements incorporate the whole or any part of the OECD model to such part of the arrangements as does so. Subsection 2 isn't relevant. Subsection 3 tells you what the OECD model is. The rules which at the passing of ICTA were contained in Article 9 of the Model Convention. And then subsection 4, the transfer pricing guidelines means, A, the version of the guidelines approved by the OECD on the 22nd of July 2010, I'll show you there are the 2010 guidelines. Such other documents as are designated by the Treasury, there aren't any. Now, it's important to note, and you'll see if you go over to page 52, there's a note, that this section, or this subsection 4, was substituted by the FA 2011 in relation to accounting periods beginning on or after the 1st of April 2011. Now, for LLC 5's earlier accounting periods, it was the original 1644 that was in force, and that said you look at the 1995 guidelines. But we say that the guidelines, whether 95 or 2010, or indeed later, they all contain the same principles. As the guidelines go on, they give more detail about how the principles apply, how they give examples and so on, but there are no material differences in terms of the principles laid down. So we submit it doesn't actually matter whether you look at the 95 or the 2010 or indeed the later ones. The other point...
Strictly, the later ones are not picked up by section 164.
No. No, but what they don't say you can't look at them, they say you have to secure, interpret relevant provisions, well, part 4, so as to secure consistency between, for example, 1471A and those guidelines. But in interpreting the guidelines themselves in my submission, understanding what the OECD was saying, I would submit that it's legitimate to see what they subsequently said by way of expansion of those principles. The other point to make is that 164 tells you that you have to do this in cases where double taxation arrangements incorporate the whole or any part of the OECD model. We're obviously not interested in double taxation at all. Now, in that DSG retail case that I mentioned, the Special Commission has said, rightly in my submission, that that doesn't matter. You're still being told, for transfer pricing purposes, even if double taxation isn't relevant, to try and interpret this legislation consistently with the OECD guidelines.
That must be right, because this is domestic provision.
Yes, exactly. It would be very odd. I don't know why it talks about the double taxation arrangements, but in any event...
Well, that's the way into the guidelines.
Well,
the guidelines were presumably originally introduced for those purposes.
Yes.
In relation to the OECD model. So I think that's probably why you have that slightly odd.
Yes, I respectfully agree.
Provision.
Just for the record, it's paragraph. I'll come back to which paragraph of DSG retail makes that point, but as my lady has said, that must be right in any event.
Can I ask a grammatical question? If
Yep.
you go back to 1641B, you have to read the part in such manner as best secures consistency between legislation and the effect, and it's the effect which is to be given, and then at the end, to so much of the arrangements as does so. What does as does so mean? As does what?
As incorporates the whole or any part of the...
But the arrangements don't incorporate the OECD.
No, it's the double taxation arrangements.
It's the part of the arrangements that incorporate the OECD model.
It's the double taxation arrangements.
Oh, I see.
Yeah.
I don't find it particularly easy to
No,
follow.
it's not a very clear statement of what you should do, I would suggest. But could I just say, it was paragraph 70 to 71 of the DSG retail case, which makes the point that my lady says is correct.
Why does it not just say consistency between the sections and the transfer pricing guidelines?
I don't know.
Is that what it means?
Ask HMRC. I think, yes, that is what it means.
This is part of the tax law rewrite project.
Yes, mark that one down.
Intended to be very clear.
Mark that one down. So that one has to, in other words, interpret, so far as possible, 147.1a in the light of those guidelines, so as to secure consistency between what 147.1a does and indeed 147.1d does, and what the guidelines are telling you you're trying to achieve.
Is there any dispute that although the legislation refers to 2010 guidelines, you can elucidate them by reference to later iterations? Is that disputed?
No, I'm afraid just for unprincipled reason that it's very helpful to us. I don't know what the correct answer is, but certainly we're very happy
I mean,
to do it.
as a matter of pure theory, it seems slightly odd that the meaning of a legislative provision can change because of something somebody else does subsequently.
That would be absolutely right, and in my submission, if it could have that effect, then that one would say, well, you can't alter the meaning by reference to the later guidelines, but if one decides that all that the later guidelines are doing is giving an example of how the earlier guidelines tell you to approach the question.
It's just helping you understand what the 2010 guidelines meant.
Yes. If you decide that that is what they're doing, then in my submission that is legitimate to look at that example. Mr. Yates reminds me that in the double taxation context there is authority that you can look at later commentaries. I think that's a slightly different point, given that this legislation is focusing you on particular guidelines.
I think I agree with that, particularly because the Treasury is given power and hasn't exercised it to bring in later versions.
Yes.
So I think we have to be mindful of what the statute.
I would respectfully agree, and not in an unprincipled way.
But I thought you wanted to rely on it as well. So you both want to rely on it.
We do,
but insofar it's helpful, but not insofar it's unhelpful.
Well, no, I'm not saying you don't look at it insofar as it's unhelpful. I'm saying, in a principled way, don't look at it if you think that this is altering what the earlier guidelines are telling you how you should approach it. Obviously, we'll have our different arguments about whether it's doing that or not.
Well, speaking for myself, any help would be an advantage.
Yes, I would agree as well, which is why I will be saying something about the later guidelines, because there are later guidelines that specifically address financial transactions. Now, going back to 147, if I may, we've seen 147.1d asks whether the actual provision differs from the provision which would have been made as between independent enterprise. So the question is, what sort of differences are relevant? We'll see from the guidelines that you do not make adjustments to the economically relevant characteristics of the transaction or the two parties to it, other than the parties' relationship. And this is a point which is addressed in the DSG retail case. Tab 10, paragraph 78, if I could take you to that. Tab 10 of the authorities bundle, paragraph 78.
Just remind me, DSG was never successfully appealed.
No, it wasn't. No. I don't think it was ever appealed.
Paragraph number?
Paragraph 78 on page 231 in the bundle. So it's a reference to 770, the earlier legislation. Requires one to determine the price which would have been paid if the parties had been independent parties dealing at arm's length. It seems clear to us that those words do not require any adjustment to be made in setting the price to the actual characteristics of the parties, other than their independence. The actual assets, business, and attributes of each party remain constant and may be relevant to the determination of the arm's length price. And then it says the language of para 1.2 is differs from the provision which would have been made between independent enterprises. It's at first sight possible those independent enterprises may not be enterprises which don't share. I think there's too many knots there, but anyway, may be enterprises which do not share the same attributes as the actual parties to the provision. But it's clear to us that that interpretation is not consistent with the OECD model. See in particular the emphasis on comparability in the extracts below, which presupposes looking at the actual characteristics of the enterprises between which provision has been made. Therefore, para 1.2a, and that's in the same terms as 147.1a, should be interpreted as requiring consideration of what provision independent enterprises sharing the characteristics of the actual enterprises would have made. And then so an example of that is, and this comes clearly from the OECD guidelines, you don't assume that if the borrower is a member of a group, that when you look at the hypothetical arm's length transaction, you don't assume that it's an orphan company. You accept that it's still a member of a group. And therefore, one of the points that's made in the guidelines is that if the borrower has implicit support from the rest of the group in relation to its borrowing transactions, in other words, the world knows that the group will not let this borrower go to the wall, that you can take that into account in looking at what the arm's length transaction would be as well, including the credit rating of the borrowing company. So that's an example of not adjusting the reality more than the relationship between the two parties in question.
Well, I understand that for the borrower, but is that true of the lender? I mean, the lender has the characteristics of the actual lender?
Well, certainly DSG Retail say it's both parties, because you're looking at what each party would have done. You're not just looking at the borrower simply because it's only the tax position of the borrower that you're interested in. It could be the next day the tax position of the lender you're interested in. But in any event, the OECD guidelines are looking at both the parties and their actual attributes and characteristics, and then transposing them across to the hypothetical transaction and saying, with those attributes, and that by attributes it includes not just what assets you've got, but also what risks you're running in relation to the transaction. With those attributes, what would have happened if you'd been independent? But that's both parties.
That seems a bit odd to me. LLC 4 is a newly created company whose only business is to take its place in the structure and receive the assets from above and pass the assets down and so on.
Well, and to have voting control of LLC.
And have voting control. If one's postulating an arm's length transaction, the obvious counterparty is not a newly created company with no other assets or business, but is a bank or other financial institution which is in the business of lending money.
Yes.
Do you really assume that the lender...
That's one of the points which my lady made about what assumptions... The legislation goes on and says there are certain things in the real world that you do not carry across to the hypothetical world. One of them is that the actual lender is not in the business of lending. We'll come on to that in a moment. Another of them is that you must not postulate the giving of a parent guarantee or a guarantee at all. So that there are certain things that the legislation specifically says you do not carry across to the hypothetical world. But my submission is, insofar as
Well, rather not, you don't carry them across, but you don't have regard to them.
you don't have regard to them. Yeah.
You don't.
My submission is that legislation is assuming that otherwise you would do so. You would regard the reality.
Save insofar as there's a specific statutory provision to the contrary,
Yeah.
you assume the characteristics of the lender are the same.
Yes.
Thank you.
So if we can go back to the legislation, I mentioned a couple of minutes ago that the arm's length provision can be no provision. And that's in section 151 on page 34. The definition of arm's length provision says it can include no provision at all. And then if I can take you to section 152 on page 35. So this applies where the actual provision is provision in relation to a security issued by one of the companies. Now the definition of security is in section 154, and it's sufficiently wide as to cover any borrowing, any lending transaction. So that in the particular case here, we do have provision in relation to a security. Irrespective of whether we had loan notes or what, every borrowing is deemed to be provision in relation to a security. So that's 1521, and then subsection 2 says, subsection 1471D, that's the comparison between the actual and the hypothetical, is to be read as requiring account to be taken of all factors. Now there's an exception to that, as we'll see, it's subject to, but all factors including whether the loan would have been made at all in the absence of the special relationship, the amount of the loan which would have been made, the rate and other terms. Now, when it says take account of all factors, my submission is that means what it says. You do take account of all factors, including all of the factors in the real world, including the risks that LLC 4 and LLC 5 were actually running in the real world. But then we're told by subsection 3, this has effect subjects to 4 and 5. And 4 is the point that we were just discussing. If a company makes a loan but it's not part of its business to make loans generally, the fact that it's not part of its business to make loans generally is to be disregarded in applying subsection 2. So in applying subsection 2, all factors doesn't include that you're not in business generally. And then subsection 5, 1471D, is to be read as requiring that in the determination of any of the matters mentioned in subsection 6, no account is to be taken of, or any inference capable of being drawn from, any guarantee provided by a company with which the issuing company has a participatory relationship. And then 6 tells you various things that might be, that the giving of a guarantee might affect and be relevant to. Now, HMRC interpret subsection 5 I'm not saying in this particular case. HMRC in practice interprets subsection 5, the reference to a guarantee, which is defined very widely on page 154 on page 39. I should take you to that first. Subsection 4. Any reference to a guarantee includes B. Any other relationship, arrangements, connection or understanding, formal or informal, such that the person making the loan to the issuing company has a reasonable expectation that in the event of a default by the issuing company, the person will be paid by or out of the assets of one or more companies. Now, I should make this point first of all. It's not suggested in this case that there was any guarantee or that the third-party covenants that the FTT said could be postulated would amount to a guarantee. So in other words, covenants to ensure that someone will receive dividends does not come within the definition of a guarantee, an understanding that the person making the loan has an expectation that in the event of default, the person will be paid by somebody else. So clear that one up. There isn't a guarantee. There wouldn't be a guarantee in the hypothetical case either. Now, HMRC interpret guarantee as not including implicit support. Remember I mentioned, and I'll take you to the OECD guidelines, that say you don't assume the company is an orphan company, and you can take account of implicit support that the borrowing company can get from the group. That implicit support, HMRC say, is not a guarantee. Now, I assume that they say that because otherwise that would appear to be contrary to the OECD guidelines that say you do take account of implicit support. But in any event, for whatever reason.
I don't think the revenue say that in all circumstances.
No, perhaps not.
To guarantee, but hopefully we don't need to go.
No, we don't need to go there. So if we just sum up where we are, we identify what the actual provision is, 1471A. In my submission, it includes not just the loan itself, but the understanding that came with it. In any event, that is part of the economically relevant characteristics of that provision. And then if you compare it with the arm's length provision and ask whether independent enterprises would have been willing to lend, the answer given by the FGT is yes if covenants are given. And obviously that's because an independent lender would not accept the informal understanding.
I mean, is your essential point, unless I've mistaken it, that the covenants and the understandings that actually exist in this case are indistinguishable?
They're indistinguishable economically.
Yes.
Legally, they're obviously vital.
Yes, but in terms of making the comparison,
yes,
what you've got is a perfectly good analogue for an arm's length transaction, which would have happened to have had the extras.
The legal extras.
The legal extras.
Now,
can I be sure I understood what your submission is in relation to 153? 153 is quite a complicated provision. Now, I understood you to say it doesn't apply here, because in the real world, there isn't a guarantee.
Yep.
But what is it actually doing? What's it trying to do in circumstances where it does apply? I'm afraid I didn't follow that.
Do you mean 152, which tells you not to look at a guarantee? 153 defines it. Is that right? Yeah, 153. Sorry.
I think it's easy to get confused
Yes.
here.
Sorry.
I think we're looking only at 152.
Yes.
Maybe easier. We can
Yep.
go on to 153, but
153 is where you have an actual guarantee as well, given by another company. But
and that might cut the relationship between the guarantor and the borrower. I think what we're concerned with is the relationship between the borrower and the lender.
yes.
Which is 153.
So 153 is applying the transfer pricing provisions to the guarantee, to an actual guarantee, and asking at what price would that have been done? Would it have been done at all between independent persons? We're not looking at that. We're not transfer pricing an actual guarantee. So we don't need to look at 153. Maybe, I don't know whether you were actually asking what 152 is doing. I don't know, I'm sorry. If, my lord, you're looking at 152 and what that's doing, that is telling you.
It's 1525. No account is to be taken of any guarantee.
So there was a debate before the Upper Tribunal as to what that is doing. One of the things that HMRC said is that, or rather what I said, is that 1525, by telling you can't take account of a guarantee given by somebody else who's not a party to the transaction, implicitly recognises that apart from that prohibition for guarantees, you're not prohibited from looking at, in the arm's length provision, from postulating there is some third party involvement.
Can we take a relatively simple example? Let's say you had an intragroup loan, but you happen to have a third-party guarantee of that loan. That third-party guarantee would not be required to be ignored under this provision.
No.
Because it isn't a guarantee given by someone in a participatory relationship. That's in the actual world. In principle, that I think you'd say that could then carry across to the hypothetical world.
Yes. Yes. Now, HMRC would agree with that. What HMRC say is, but if you do not have a third-party involvement in the actual world, then what they call the two-party rule, the two-person rule in 147A, forbids you from postulating any third-party involvement in the hypothetical world. Now, if we just look at that for a moment, one of the things that the experts agreed on before the FTT was that in an independent lending transaction, obviously of some size, independent lenders almost always, this is what they said, insist upon covenants by other members of the group to ensure that profits aren't diverted elsewhere in the group. And they said, but this is hardly ever seen in a transaction between members of a group. A group lending transaction, you wouldn't have that, obviously, because you all sort of trust each other. But they say, you would almost always require that if you're an independent lender.
Are you saying the experts agreed on that?
Yes. So I can take you to that. It's at paragraph 78 of the FCT decision. If you look at paragraph 78, what the FTT was doing there was referring to two separate reports with identical paragraphs, because the experts weren't prepared to agree a joint report, but they were prepared to agree identical things. Very odd. But anyway, if you go to G, 2/3 of the way down the page, that's there talking about protections to ensure the cash flow could not be diverted in any way. And possible additional clauses would include a negative pledge on further indebtedness, a change of control clause, a restriction on being able to lend money to other entity. These are well-known standard clauses required in almost every external debt transaction, though to emphasize, one would not expect to see them in an intercompany loan transaction within a group. Now, that's the reality. You don't get it in the intercompany transaction, you don't need it, but you do require that third-party involvement in the independent world. Now, if HMRC were right in saying, if you don't have a third-party involvement in the actual world, you cannot postulate it in the hypothetical world, then you would always apply the transfer pricing provisions and say, I'm sorry, the lender isn't prepared to lend without those covenants, therefore you postulate no loan at all. Now, that's the result of their argument that, and they say they base it on the two-person rule. Now, it's very odd because this two-person rule is you have to postulate provision between two persons. That must be right. It doesn't tell you what else they may be involved in the transaction. And my submission is, if the revenues say, well, you can postulate third-party involvement if it's there in the actual transaction, that immediately disposes of this so-called reliance on the two-person rule. They accept that you can have third-party involvement in the actual world.
You can't have it both ways.
Right. So they're saying, but you've got to have it in the actual to be able to postulate it.
Yes.
But the experts are saying, you don't have it in the actual with these additional covenants, protections to avoid diversion, but they're almost always insisted upon in the real independent world. Now, that point is so significant in my submission, it shows that HMRC must be wrong, otherwise the legislation is, as it were, barking, that you don't have to have the third-party involvement in the actual world in order to be able to justifiably have it in the hypothetical world. And the reason is, you can postulate it because it's doing no more than reflecting the economic reality in the actual world. In other words, it's not altering the economically relevant characteristics of the actual transaction. It's simply something which an independent lender wants, as it were, as a part of the formalities of the transaction. It doesn't alter the real risks. So can I now take you to the OECD guidelines? I think I've taken you to the domestic legislation. So this is tab 19 of the authorities bundle. we're not setting out in these in the authorities bundle the whole of the guidelines. So 19 is the 1995 guidelines. And I'm very happy to take you to the 1995 guidelines because they apply to the first few accounting periods of LLC 5. But the same points are made in the 2010 guidelines, and I think this is going to be all common ground. So first of all, 1.6. Which is on page 666. It sets out Article 9 of the Convention, which you see there. And it says, by seeking to adjust profits by reference to the conditions which would have obtained between independent enterprises in comparable transactions and comparable circumstances, the arm's length principle follows the approach of treating the members of a group as operating as separate entities rather than as inseparable parts of a single unified business. So stopping there, comparable transactions and comparable circumstances, first of all, and then, yes, as separate entities rather than as inseparable parts of a single unified business. But that doesn't mean you ignore the fact that the company is in fact part of the group, because that is one of the comparable circumstances. Because the separate entity approach treats the members of the group as if they were independent enterprises, attention is focused on the nature of the dealings between those members. That's paragraph 1.6. And then paragraph 115.
What's MNE?
MNE is multinational enterprise. Paragraph 115 on page 670. Application of the arm's length principle is generally based on a comparison of the conditions in a controlled transaction with the conditions in transactions between independent enterprises. In order for such comparisons to be useful, the economically relevant characteristics of the situations being compared must be sufficiently comparable. And down the page it talks about risk. We'll come on to that. Paragraph 117. Paragraph 117. In making these comparisons, material differences between the compared transactions should be taken into account. In order to establish the degree of actual comparability and then to make appropriate adjustments to establish arm's length conditions, it's necessary to compare attributes of the transactions or enterprises that would affect conditions in arm's length dealings. Attributes that may be important include the characteristics of the property or services transferred, the functions performed by the parties, taking into account assets used and risks assumed, the contractual terms, the economic circumstances of the parties, and the business strategies pursued by the parties. And it says it's going to discuss them in more detail. So if we look at page 672 over the page, 120 under the heading Functional Analysis, in dealings between two independent enterprises, compensation usually will reflect the functions that each enterprise performs, taking account assets used and risks assumed. Therefore, in determining whether controlled and uncontrolled transactions or entities are comparable, comparison of the functions taken on by the parties is necessary. This comparison is based on a functional analysis which seeks to identify and to compare the economically significant activities and responsibilities undertaken or to be undertaken by the independent and associated enterprises. For this purpose, particular attention should be paid to the structure and organisation of the group. And then 123 on page 673, it may also be relevant and useful in comparing the functions performed to consider the risks assumed by the respective parties. In the open market, the assumption of increased risk will also be compensated by an increase in the expected return. Therefore, controlled and uncontrolled transactions and entities are not comparable if there are significant differences in the risks assumed for which appropriate adjustments cannot be made. Functional analysis is incomplete unless the material risks assumed by each party have been considered, since the assumption or allocation of risks would influence the conditions of transactions between the associated enterprises. And then at 124 it talks about the types of risks to consider: risk of loss, risk of success, and so on and so forth, credit risks. So you have to look at the reality of what credit risk LLC 4 and LLC 5 were assuming. And then 125, the functions carried out will determine to some extent the allocation of risks between the parties, and therefore the conditions each party would expect in arm's length dealings. And then if we go to paragraph 131, so 130 is under the heading economic circumstances, and then 131 is under business strategies, and then at the bottom of 131 it will also be relevant to consider whether business strategies have been devised by the group or by a member of the group acting separately, and the nature and extent of the involvement of other members of the group necessary for the purpose of implementing the business strategy. So that's a recognition that this company is a member of the group. We don't ignore that. And then 137.
Sorry, when you refer to which company are you referring to?
Well,
when you say this company,
I'm focusing, I suppose, on LLC 5 rather, and the fact that in the real world it has this understanding with other members of the group. Then at 137, I should mention that we're told that there are two circumstances in which one can recharacterize an actual transaction and, for example, treat a loan as really being equity. I only mention that because that's not part of it's never been part of HMRC's case, that you could recharacterize the transaction as really being equity. They simply say the loan would not have been made in the real world because of the credit risk involved. Now, the same points are made in the 2010 guidelines about having to look at the actual risks assumed, and I won't take you to all those again, if that's all right. I can tell you that there are paragraphs 1.6, 133 to 38, and 142 to 51. And then what I did want to do, and I'll be careful about this only being an example of what the existing guidelines are telling you anyway, is take you to the 2022 guidelines. This is tab 21, and paragraph 1.177, which is on page 916. And it's under the heading M&E Group Synergies. And effectively what it's saying is group synergies can be taken into account.
you're talking about 177, are you?
177, exactly, and 1178. And if I can go to 1184 on page 918, and it's an example. So it gives an example of P being the parent company of a group. P's got a AAA credit rating. S is a member of the group. On a standalone basis, the strength of S's balance sheet would support a credit rating of only Baa. Nevertheless, because of S's membership in the P group, large independent lenders are willing to lend to it at interest rates that will be charged to independent borrowers with an A rating. And then it goes on to say what you have to do when you have a borrowing between S and T, another member of the group. And effectively it says that when S is borrowing, you can take account of the fact that it's a member of the group and that it has the implicit support of P and the rest of the group in working out what independent lenders would be willing to do and how much and at what rate of interest. So that's just an example of how you take account of the membership of the group. And then if we go to paragraph 1046 on page 414 of it's page 933 of the bundle. 1056. Again, there's a point about being part of the group being recognised. In the case of a loan from the parent company of the group to a subsidiary, the parent already has control and ownership of the subsidiary, which would make the granting of security less relevant to its risk analysis as a lender. Therefore, in evaluating the pricing of a loan between associated enterprises, it's important to consider that the absence of contractual rights over the assets of the borrowing entity doesn't necessarily reflect the economic reality of the risk inherent in the loan. If the assets of the business are not already pledged as security elsewhere, it'll be appropriate to consider under Chapter 1 analysis whether those assets are available to act as collateral for the otherwise unsecured loan and the consequent impact on the pricing of the loan. So that's just simply an example of how you take account of the reality about being in a group. And then the final point I wanted to mention there is the recognition that obviously associated companies frequently deal informally. This is at page 939. It's under the heading Covenants. And if you go to 1086 on page 940, there may be less information asymmetry between entities, that is better visibility, in the intra-group context than in situations involving unrelated parties. Intra-group lenders may choose not to have covenants on loans to associated enterprises, partly because they're less likely to suffer information asymmetry, and because it's less likely that one part of a group would seek to take the same kind of action as an independent lender in the event of a covenant breach, nor would it usually seek to impose the same kind of restrictions. So that's an example of the restrictions that the independent experts mentioned about avoiding any diversion. Where there is an absence of covenants in any written agreement between the parties, it would be appropriate to consider under Chapter 1 guidance whether there is in practice the equivalent of a maintenance covenant between the parties and the consequential impact upon the pricing of the loan. So that's the obvious point, that you may not have actual formal covenants, but you may have in practice the same thing. So that's what I was going to take you to in terms of the OECD guidelines. Can I now take you to the FTT decision? And I can do that relatively quickly because really the debate now in this court is a different one from the debate before the FTT, where the FTT was considering, would an independent lender be willing to lend without covenants? No. With covenants? Yes. And then there was a lot of detail about what sort of covenants. But the FTT made findings about that, and I don't think I need to go through all those findings, except in relation to an Edwards and Bairstow challenge by HMRC, which Mr. Yates is unfortunately going to have to deal with. So if I could take you to the FTT decision, and I can start, you may think worryingly, at paragraph 2, but that's just because it sets out what the issues were at that time. This is paragraph 2.3 on page 154, well, it's page 1 of the decision itself. You see it says the question, this is the transfer pricing question at 2.3, whether the loans between 5 and 4 differ from those which would have been made between independent enterprises, taking account of all relevant information, including A, would the parties have entered into the loans on the same terms and in the same amounts? B, if the answer is no, would they as independent enterprises have entered into the loans at all? And if so, in what amounts, at what rates of interest, and on what other terms? Now, although it says including, those were the only questions before the FTT. It was A and B. It was those, as it were, hypothetical factual questions, not the one that is being raised now, which is, but you cannot postulate third-party covenants anyway. And then I can go to paragraph 67 to 68. Which is on page 31 of the decision, page 184 of the bundle, where there's a reference to the expert evidence. And so there was Mr. Ashley, who is recorded at 68 as having 30 years' experience in interest rate markets and debt capital markets, and Mr. Gaisford, who was an economist who admittedly did not have experience of those markets. And then if you go to paragraph 69, the top of page 32, they, the experts, agreed that an independent lender would, on the strength of the BGI business, be willing to lend $4 billion to LLC5, but would have required covenants from LLC5 to do so. And then there's a discussion, quite a long discussion, about what sort of covenants they would have been, because it was suggested by HMRC that although the experts agreed identical things in their reports, they were in fact disagreed about which covenants they would be. And that's the basis of HMRC's Edwards and Bairstow challenge, which was rejected by the Upper Tribunal. I don't think I need to take you to that now, because I say Mr. Yates is going to deal with that. Then if we go to paragraph 74, paragraph 74, we have Mr. Ashley saying such covenants would be given. Mr. Gaisford was of the view that not only would it be complex and costly to obtain those covenants, but because it wouldn't be at arm's length, it's not permissible, as with a guarantee, to postulate that LLC5's parent, LLC4, would assist it. So, Mr. Sorry.
I just pause on the not permissible. The expert there appears to be forming a legal
Yes,
view.
and we objected to that. And the FTT said, this is at paragraphs 83 onwards, the FTT recorded our objection to that and said, yes, paragraph 86, I agree with Mr. Prosser on that. The interpretation of the guidelines is a matter of law. But the point I wanted to make, really, in relation to paragraph 74, was that even Mr. Ashley was not suggesting that you can't postulate third-party covenants because that would alter...
Do you mean Mr.
Oh, Mr. Gaisford, I'm sorry. Mr. Gaisford wasn't suggesting that you can't postulate third-party covenants because that would alter the economically relevant characteristics of the transaction. And I think the reason for that is because that bit of the report I took you to, he recognised that actually third-party covenants would replicate the economically relevant characteristics of the real world. So that's why that wasn't part of his argument. But in any event, it wasn't part of HMRC's argument. And then on paragraph 77 and 78, we get the discussion about which covenants, and as I say, I won't take you to all of that, but I can summarise it in this way. The only disagreement between them was the cost and complexity point, which Mr. Gaisford said would prevent the deal going ahead, or at least he said it wouldn't stop the independent lender being willing to lend. He said it wouldn't be a deal breaker. But his point about cost and complexity was really that it wouldn't make sense for the BlackRock group to permit LLC5 to borrow because it would be more cheaper to do it elsewhere. And that's the group point of view, which the FTT...
Is that the 40 million?
Yes, exactly. But it costs the group more if an independent lender lends to LLC5. But the FTT and the Upper Tribunal both rejected that argument, that this isn't a group analysis of where is it best in the group that the company borrows. You have to take the company as it is with its actual characteristics and not adopt a group point of view and say where would it be best for the group to borrow. So that was the other disagreement between the experts, or at least the point made by Mr. Gaisford was a parent guarantee would have been required by an independent lender. Mr. Ashley said no, it wouldn't. And the FTT agreed with Mr. Ashley, and there's no appeal against that on Edwards and Bairstow grounds. So that point about a guarantee is not live. And the FTT makes its finding on parent guarantee at paragraphs 80 to 82. And then if I can take you to paragraph 92. Which Mr. Hewitt's case is that the transaction simply would not have taken place. So that, and I'm repeating myself, but this is made very clear in the FTT decision, that was his only argument. It wasn't, well, even if it would have done, it would have altered the material, economically relevant characteristics and so on. Then if you go to paragraph 96, there's a reference there to the primary case advanced by me. That's because I had that alternative case about the co-investor point, but you can assume that the independent lender also owns the common shares in LLC6. I was relying on the evidence of Mr. Ashley because he was the expert saying that a lender would be prepared to lend with covenants without a guarantee. And then at 97, the differences are summarised by Mr. Gaisford. So the first paragraph, we agree you'd have to put in place some covenants. We disagree how easy it would be, but we agree that had they been in place, you could satisfy the concerns of an independent lender. And then, where we disagree, second paragraph there, the implications. The first implication is the resulting commercial position for the group of a whole is worse than the simple alternative. That's the group point of view point. And then the second difference, this is the third subparagraph there, between us is, I believe, that you'd be left with a transaction which still fails the arm's length test. Now, that isn't the materially different economic characteristics point. That's a different point, which Mr. Hewitt didn't take himself. You see on paragraph 98. I didn't understand HMRC to be relying on the second of Mr. Gaisford differences, and as no argument was advanced by Mr. Hewitt on this basis, it needn't be considered. And as I understand it, that has never been advanced by Mr. Hewitt. So you see at 99 and 100, the FTT rejecting the group approach as inconsistent with the guidelines, and as I say, the Upper Tribunal did that as well. Rejected that argument. And then 102, you get the decision of the FTT. The experts agreed an independent lender would have entered into an arrangement subject to being able to obtain the necessary covenants. On balance, given Mr. Gaisford accepted his concerns in relation to cost and complexity didn't amount to deal breakers, I prefer the evidence of Mr. Ashley that the covenants would have been forthcoming. Similarly, no need for a parental support. Therefore, 103, for the reasons above, I find, although an independent enterprise wouldn't have entered into the loan on the same terms as the actual transaction, it would, subject to the covenants described above, have entered into the loans on the same terms as the parties. And therefore, as I said, it doesn't consider my alternative argument. So that's the FTT decision on transfer pricing. And as we've seen, there's no finding at all, no discussion even about this economically relevant characteristics point, because it wasn't being run by HMRC. So then I take you to the Upper Tribunal decision on the transfer pricing issue. The Upper Tribunal's decision is in the core bundle at tab 6. And we're looking here at paragraphs 35 to 100. I'm not going to take you to all of them. And if you go to paragraph 36, which is the first of HMRC's grounds of appeal, this is page 10 of the decision, page 99 of the bundle. The first ground of appeal was that the FTT erred in law by concluding that while an independent hypothetical arm's length enterprise would not have entered into the loans on the same terms of the actual transaction, it would have done so if certain covenants had been given by entities other than LLC5. The argument is that the FTT impermissibly altered the economically relevant characteristics by reading covenants from third parties, other than LLC5, into the arm's length transaction. This was impermissible because section 147(1)A limits the provision of a loan to one made between two parties. Now, so that's actually merging two different points in a way. There's the economically relevant characteristics point, but also something about what 147(1)A says, which is you have to look at provision between two parties. Now, on the latter point, we know that HMRC accept you can take account of third-party provision. They say, in other words, someone other than the two persons. If it's in the actual world, then you can postulate it also in the hypothetical world. I've made my point that if that is the rule, then you're not basing that on the two-person rule. But secondly, that can't be the rule, because it would mean that in the example given by the experts, where in the independent world, a lender will almost always insist upon covenants, but they are virtually never given in the intergroup transaction. You'd get the absurdity that no one would ever get a deduction. Except, of course, if they say, oh, that's the rule, apparently we need to include these covenants in our actual transaction, even though we don't need them. We need them for transfer pricing purposes, so we can say we've got them in the actual, and therefore we can have them in the hypothetical. And we'll see in a moment, the Upper Tribunal said that would be unscrupulous on the part of the group to do that, and we can spot that if we see it. Now, that leads to absurdity, really. It's the catch-22, that if you don't have them in the actual, then you can't postulate.
You say that would be pointless window dressing.
It would be pointless window dressing, and the Upper Tribunal says it's window dressing. It says you need them, but if you do it to get out of the transfer pricing rules, then that's unscrupulous, and we can spot it when we see it. I don't know what the consequences of spotting it when you've seen it, but in any event, it leads to absurdity that either you need it, which in my submission is not so, or if you do have it, then somehow it's abusive. But my answer is you don't need it if all you're doing with including the third-party covenants in the hypothetical world is giving effect to the reality of the actual world. It's just formalizing the actual world, the position of the actual world. And then paragraph 37.
How does your submission on that fit with the point that you accepted when we were going through the legislation, that 2 means 2, not 2 or 3?
Right. 2 means you have to concentrate on a provision between 2 persons only. That's what you're transfer pricing. But in asking what is the economic reality between those 2 persons, you can take account, for example, of the fact that one of them is a member of a group. That's part of the reality. You also can take account of, in the actual world, that there's an understanding between them, as I've mentioned. Then you go to the hypothetical world and you say, we've got to make sure that the risks that we've identified in the actual world are also postulated in the independent world, albeit that the independent lender may want something more formal than that, which may include covenants from somebody else. The fact that they require covenants from somebody else doesn't mean that you've breached that 2-person rule. It simply means that you're focusing on the arm's length transaction or otherwise between those hypothetical 2 persons. You may have a service effectively being provided by someone else as well.
I mean, it's not really a service, is it? It's not like, I mean, some of the counter examples,
they weren't very good examples
given. Getting some lawyer to draft your documentation.
That wasn't a very good example.
This is rather different. It's not just getting someone to do something. It's getting an extra legal right in return for your money, which you don't have in the real world.
Right. But can I just repeat my point that the HMRC accept that 2-person rule is not breached if you have that covenant in the actual world. They say you can postulate a third-party covenant in the hypothetical independent world, provided...
Well, I've understood that, but I still haven't quite understood how your argument, or indeed HMRC's acceptance, fits with the 2 means 2 and not 3 point.
Well, it means...
Because if you're asking, what is the price for a transaction in the hypothetical world between A, B, and C, that's not 2 persons, that's between 3 persons. Right. And that does seem to me to be what you're asking.
No, I would say no.
You're not.
What I'm focusing on is the transaction between LLC 4 and LLC 5. I'm saying that was entered into with an understanding. Now, it may be, we've seen that the definition of transaction and therefore of provision includes an understanding. So it's perfectly possible that that understanding is something which itself needs to be looked at from a transfer pricing point of view. So that, for example, if you had a UK parent which is party to that understanding, is providing a benefit, if you don't call it a service, by saying, don't worry, I'll make sure that you receive the dividends that you're expecting to receive. Suppose that's a UK parent and everyone else in the group is offshore, HMRC would be entitled to say, should we transfer price that understanding as being something which should be paid for in favour of that parent company that's providing that understanding. So that's a separate exercise altogether. And that really was what Mr. Gaisford was saying, that this is not an arm's length transaction because it wasn't actually being priced. That is not part of HMRC's case. But just because you have something else going on, which may be itself something that you need to look at from a transfer pricing view, doesn't mean that you're breaching the two-person rule, because each provision is a two-person provision. There'd be another one going on. We're focusing on this particular provision between LLC 4 and LLC 5.
It's one way of looking at it. We're looking at a loan from A to B. We're looking at the terms on which A might be prepared, would be prepared to provide that loan. I think your point is that A is only prepared to provide that loan on the basis of certain things, which may include some third-party support, but it's still saying to B, I won't lend to you without X, Y, Z.
And could I just interrupt and say, and B wouldn't borrow without the understanding as well?
And separately, let's say that's some sort of support, not being a guarantee for these purposes from C. There may be a separate exercise between A and C as to how much C would charge A, and indeed whether C would be prepared to provide that benefit, if you like, to A, but you're saying that's a separate exercise.
Yes. And may I say, your mention that it isn't a guarantee raises the point also, 1525, which says you can't take account of a guarantee given by somebody else, presupposes that there's no bar, no prohibition on when you're looking at the provision between the two persons, at supposing or accepting in the real world or in the hypothetical world that there is something going on or that needs to be going on involving a third party as well. Otherwise, why would you have 1525 saying you can't take account of a guarantee? That is, in a sense, that is clearly a third person involvement. So that if there were a two-person rule that said, not only are we looking at provision between two persons, but we have to imagine that no other person is involved at all. If that were the rule, then why on earth is 1525 saying you can't take account of a guarantee?
Well, you can't take account of a parent guarantee, but I think you say you can take account of a guarantee given by somebody who's not in the group.
Right, but the point is, you're taking account, the fact that you're being told not to take account of a parent guarantee is surely implicitly accepting that the two-person rule does not mean that you can't take account of any third-party involvement.
Yes, I see. Can I rephrase the way my lady put it? If a lender is going to lend money to a borrower, they will set out in a facilities letter all the preconditions before the loan is made. And your point is, those are terms between A and B, even if one of the preconditions is that C gives this covenant and D gives that covenant.
Yes, as the experts accepted in the real world would be required. Now, you might say, you would accept that is not, although it's a term of the deal between A and B, it nevertheless involves somebody else as well. But my submission is there's no prohibition on that. The question is, the only question is, if you're postulating such third-party involvement in the hypothetical world, when the actual transaction or the covenant or whatever it is didn't happen in the real world, are you thereby altering the economically relevant characteristics?
Are you changing the risk?
Are you changing the risk? And if the answer is, in the real world, because of an informal understanding there wasn't such risk, then the answer is no. Obviously, if in the actual world, let's suppose LLC 4 said, I'll lend you the money, I don't care whether you can repay it or not. Or LLC 5 said, I'll borrow the money and I don't care whether I can repay it or not. I don't care about the risk. That would be a very different transaction from the actual one we've got here. So I was referring to the Upper Tribunal decision, and we go to paragraph 44 where we see what Mr. Ewart submitted. So he says 1471A refers to the provision made between any two persons. That was necessarily limited to the provision between the borrower and the lender. The hypothetical transaction has to be comparable to the actual transaction in terms of its economically relevant characteristics, and therefore it's not permissible to add covenants from third parties. Now, just stopping there, the therefore seems to be arguing that irrespective of the facts of the actual transaction, in other words, irrespective of the understanding that I keep mentioning, just by adding third-party covenants, you are altering the economically relevant characteristics. Now, as a generalized proposition, that cannot be right. It's a fact-sensitive question.
I apologise. Are you reading from 44?
44.
Yeah.
And then 45.
That's all submission, isn't it? I mean, that's not the.
That's all submission. Yep.
That's all submission.
Yep. And my reply at 45 is the FTT was entitled to take account of covenants which didn't exist. And then over the page, the covenants were akin to services provided by third parties. Well, maybe that's a bad point, but in any event, in order to replicate the economically relevant characteristics of the actual transaction. So that was my point. The FTT was therefore allowed to take them into account. And then there's a mention of 1525. You see, the difficulty was that the HMRC was saying this two-person rule says you can't take account of them. That is a very different point from saying, are you altering the economically relevant characteristics? So I was dealing with what I thought anyway, was two different arguments. And 1525 I was referring to say this two-person rule doesn't prohibit taking account of third-party covenants, C1525. Then at 47, the UT say, in fairness to the FTT, HMRC aren't relying on the same arguments. Then at 49, the FTT made an important finding of fact, that the loans wouldn't have been made without covenants. Now, HMRC seem to be arguing in their skeleton argument for this court that somehow is an objection to my reliance on the understanding. I don't understand that, the informal understanding. It's true that the FTT said these wouldn't have happened without covenants, but it simply wasn't addressing the question of did those covenants alter the economically relevant characteristics. So then at 52, the focus of 1471A is on the two persons. And as I say, I accept that. Then there's a reference to the arm's length principle at 53, and the need for comparability at 54, quoting from the guidelines. 55, economically relevant characteristics, that's all accepted. 56, reference to DSG retail, and you've got to share the characteristics of the actual enterprises. 57, risk is of particular significance, and reference to the guidelines about they wouldn't be comparable if there are differences in the risks assumed. 58, the experts were agreed that the main concern of the independent lender would be the risks around the fact that the borrowers in the position of LLC5 had no control over the dividend flow. In the actual transaction, LLC4, through its ownership of the LLC6 common shares, controlled LLC6, and so the dividend flow to LLC5. LLC4 did not therefore need covenants from LLC6 or BGI. In the hypothetical transaction, however, the dividend flow would need to be secured so far as possible, and this is what the covenant sought to do. Mr. Prosser said this was necessary to replicate the actual risks assumed by LLC4 in the loans. And again, there's a reference to services, which is perhaps not a good way of putting it, which didn't affect the substantive provision under consideration. By contrast, Mr. Ewart submitted, not only did this materially alter the economically relevant characteristics, it also changed the surrounding circumstances and context of the actual transaction, which is not permissible. So just stopping there, Mr. Ewart there seems to be making 2 points. One, it alters the economically relevant characteristics. 2, it changes the surrounding circumstances and context of the actual transaction. Now, I don't know what that second point is saying, really. If it doesn't alter the economically relevant characteristics, why, just because it changes the surrounding circumstances or the context, why does that matter? Anyway, 59, we agree with Mr. Ewart. Importing third-party covenants into a hypothetical transaction that didn't exist in the actual transaction changes the nature of the provision. So just stopping there, that seems to be a generalized proposition that if you import covenants that weren't actually there, that necessarily changes the nature of the provision. Maybe that's an unfair reading. Maybe he's not making, he actually wasn't making that generalized point. Then reading on, by permitting the introduction of third-party covenants, the FTT essentially compared a different transaction to the actual one. Well, obviously, it's true that third-party covenants didn't exist in the real world, but that of itself doesn't matter if it's replicating the economic characteristics. It enabled the FTT to reach the conclusion that the same loans and terms would have occurred at arm's length. However, we don't consider that new third-party covenants that were not present in the actual transaction and which materially alter the economically relevant characteristics of the transaction can be so imposed. What the UT never does in its decision is explain why importing third-party covenants materially affects the economically relevant characteristics. It appears to assume that it did, or indeed that it necessarily did, but it never says why it did, given it never looks at the actual risks assumed in the actual transaction and then say these were different. It simply says importing third-party covenants alters the economically relevant characteristics. And I would submit, if I've interpreted that correctly, and that it's saying it does without me needing to look at the actual risks being assumed, it's simply that you've got covenants that weren't there before, that must be an error of law. But obviously, my submission goes further than that and says, if the Upper Tribunal had looked at the actual risks being assumed, then it would have said they're not being altered by having third-party covenants.
Indeed, your case is not that it's permissible to have third-party covenants, but it's necessary.
It's required.
Yeah.
It's required, absolutely.
But it's so standard that it's normal. I mean, it's just...
Well, in terms of not the covenants in our case, not all the covenants in our case, but some of them.
The first two were the key ones.
The negative ones of not diverting, they're standard. Maybe I can't go that far in relation to all of them.
Well, there was some dispute as to quite what was and quite what wasn't.
Yeah.
But yes.
And then there's a reference.
Sorry, were you going to go on through this? I mean, there seems, having reached a decision, we then seem to go around the course again.
It does rather go around the course again.
Some length. Are you able to...
Could I just read on? Could I just jump on to? I won't read about what's said about 14525 and what you infer from that. But could I just go down to 71 and see what's said there? Because this is about what happens if you don't have covenants in the real world. So that 71 says, what 1525 shows is that guarantees from third parties affect the substance of the loan transaction. Parliament has decided it should be left out of account. This strongly indicates that covenants from third parties supporting the loan transaction similarly affect its substance. I would suggest 1525 doesn't tell you anything about anything other than guarantees and that they must be disregarded. In the case of covenants that are not precluded by 1525, these can only be taken into account if they were provided in the actual transaction. Wrong in my submission. It all depends on whether they alter the economically relevant characteristics. If that were not so, the arm's length transaction would not be sufficiently comparable. But again, I would respectfully suggest no. It's our view Mr. Ewart was correct to submit that the surrounding circumstances, such as the provision of third-party covenants, must be the same in both transactions to ensure there's a comparison of like with like.
That has the difficulty with the two-party argument. We've got three parties.
We've got three parties. My difficulty is, where is this surrounding circumstances point coming from, if it's different from the economically relevant characteristics point? But then, 72, we understand the effect of this, as Mr. Prosser argued, LLC 5 would not have been challenged if it had gone through the other artificial exercise in the actual transaction of having covenants in place with LLC 4 and LLC 6 and BPI and so on, as set out at the decision. The BlackRock Group would not have needed to have such covenants in place in the actual transaction because these were intergroup companies. But if they went through that artificial process, HMRC would have had to concede it would be possible to look at covenants provided by third parties when considering the arm's length transaction. This would therefore be open to abuse by a group determined to uphold the transaction for transfer pricing purposes. Now, just stopping there, I don't understand why it's an abuse if the objection is you just haven't got them in the real world. Why is it abusive to say, all right, I'll have them then? If that artificial exercise is needed, I'll do it. But what it really means is, how can the transfer pricing provisions really be thought of as working as to require you to go through that artificial exercise? That cannot be right.
Which in your submission doesn't actually change the economics at all.
Yes, exactly. If it doesn't change the economics, why do you need to do it? Clearly the Upper Tribunal thought it does change the economics, necessarily changes the economics, but that's because it didn't look at the facts of our case. Although we did refer to the evidence that I've taken you to, it just doesn't affect the economic reality.
This doesn't seem to be a factual conclusion. It seems to be a sort of a priori conclusion.
I would say,
if you've got covenants from other people, which you need, you're getting something different.
You're necessarily getting something different, exactly. And then 73, we recognise...
Sorry, just pause there. Are you saying that if the UT were going to take the approach that they did, they would need to not only decide that the FTT were in error of law on this, but then go on to engage with the firm?
Yes.
Which you say they didn't.
Well, they decided there was an error of law without having engaged in the facts. And that is in other words, you can't jump to say there's an error of law by the FTT and then engage with the facts. In my submission, the first thing you have to do is, did the FTT reach the right decision, even if it didn't consider this point, having regard to the facts, the undisputed facts? And if the answer is, having regard to the undisputed facts, they would have reached the same decision, I would suggest there can't be an error of law. I mean, particularly given that the FTT wasn't asked to consider this point. But
can I go back at some stage to why is it 1525 there? If in the real world a lender, a group lender, takes account of the fact that there's a parent guarantee, so it's prepared to lend to a subsidiary, why don't you take that account of that in the hypothetical world? What's the legislative purpose behind 1525? I haven't understood that.
I think that the legislative purpose is, it probably is the case that 1525 assumes you have an actual guarantee, parent guarantee, and that puts the subsidiary in a better position as a result, in that, well, much better position, in that someone's prepared to lend to it and maybe at a lower rate of interest.
It may be the easiest example is a very thinly capitalised subsidiary, where a bank would not lend to that subsidiary directly because it hasn't got enough equity, assets or whatever it is, but with a fantastic parent company guarantee, a lender would, and the legislation says leave that out of account.
Leave that out of account. Now, the legislation maybe is postulating you've got one in the actual world, and therefore on the face of it you read it across to the hypothetical world. But because that makes such a fundamental difference to the transaction, in a sense the lender is really lending to the parent on the faith of the guarantee of the parent, not really the subsidiary at all, perhaps. That would be an extreme example if it's thinly capitalised. But that Parliament, I haven't got a simple answer as to why Parliament picked out guarantees and nothing else. That was debated.
I mean, at its most basic, I understand transfer pricing to be about, you don't want people to get deductions for paying interest when, if it wasn't for the fact that it was all done intra-group, it wouldn't have happened. But I don't understand why there's that objection in the case for the parent guarantee.
Well, can I just give this point? This isn't really an answer to that. Other legislation, for example in Australia, they don't have that prohibition. And the cases show that the court is prepared to postulate a guarantee in a case where you've got a subsidiary which is a member of a group, and it borrows from another member of a group at an incredibly high rate of interest. And it tries to justify that on the basis that I'm all on my own here. And the revenue authorities say, and the Australian courts agree, that you're not actually on your own. You are a member of a group, and that would be formalised within the group by a parent guarantee. And therefore, we have to postulate in asking whether this is an excessive rate of interest that you're borrowing, that there is a parent guarantee. So in other words, it works both ways. It can't be that this guarantee point, prohibition on a guarantee, simply works in favour of HMRC. Or at least if it does, it's because the legislation only works one way. The legislation only works to deny a potential tax advantage. So that if you have a company which, maybe I shouldn't be speculating with an example, but in any event, I cannot answer the question why a guarantee in particular is chosen as the object of the prohibition. But my point is that it doesn't enable you to say that third-party involvement generally.
I can see that, and it may be that this really doesn't matter. It doesn't make any difference. But just pursuing it for a moment, suppose in the hypothetical world, a loan to a subsidiary without a parent guarantee would be very risky. So the interest rate would be 20% a year, whereas a loan to the same subsidiary with a parent guarantee would be a much lower risk. So the rate of interest charged would only be 5% a year. This 1525 would seem to allow, contrary to the spirit of legislation, the intra-group loan in the real world, the actual transaction, to be charged 20%, which is much higher than one would think ought to be allowed. But I don't understand.
Possibly, you may verge into saying they wouldn't be prepared to lend at all.
Just to cut through this, I think the simple answer is you can't use the transfer pricing rules to get a better tax result than the actual.
Certainly, if the actual rate is 20%, then you can't say, it should be less. The taxpayer can't say it should be less, so that it's taxed on a lower amount, because if it's receiving 20%, then it gets taxed on it. And the transfer pricing provisions don't, as I was saying, they don't work both ways.
Sorry, I've taken up enough time with that.
Well, I'm sorry, I haven't got a satisfactory answer to that, but we struggled with it before the Upper Tribunal. There's obviously some thinking behind it, but I'm not sure exactly what that thinking is. But just to finish off, and this is the end of my submissions on transfer pricing, if we look at what the Upper Tribunal said at 73 to 75, so they say it's open to abuse if you actually put in covenants just because you need them for transfer pricing purposes. They say 1525 covers the unnecessary introduction of guarantees but doesn't cover covenants. Therefore, they could be used unscrupulously by groups seeking to gain a tax advantage. 74, however, believe this is unlikely to cause such a problem in practice. It would be very obvious if groups have sought to manipulate the actual transaction in that way by including wholly unnecessary covenants. So I don't understand why you're manipulating the transaction just by including unnecessary covenants. I would submit you're not manipulating the economically relevant characteristics of the transaction by including those covenants. You're simply formalizing the, if you've got that understanding within the group anyway. But when the tribunal says it's very obvious, I don't know what they mean by very obvious in the sense of what are the revenue going to do about it? Is it that the general anti-abuse rule applies? I don't understand what the Upper Tribunal is saying there about what follows from it being obvious. But then finally, 75, we accept there's nothing in the legislation or the guidelines that expressly rules out third-party involvement. But we consider that the focus of the legislation is clear. It's on the provision made as between any two persons. And the only substantive changes that are tested by the arm's length provision are the loans themselves, such as the interest rate. Now, third-party covenants that were not given as part of in support of the actual transaction cannot be considered to be part of the hypothetical transaction, as this materially changes the surrounding circumstances and alters the economically relevant characteristics. And again, that seems, I would suggest, to be a generalized proposition that is not bothered about looking at the actual risks assumed and simply saying, well, it must alter the substance and the economically relevant characteristics. And my submission is that's wrong. And then, just before closing, can I just refer to a couple of paragraphs of HMRC's skeleton where they address this transfer pricing issue? Because it seems to me that they are making a totally different point from the one that the Upper Tribunal was making. And this is paragraph 16 of their skeleton argument. So 16 on page 61 of the core bundle. The correct application of the arm's length principle requires that the connection between the two parties is severed before the transfer pricing analysis takes place. This is the separate entity approach referred to in paragraph 1.6. The guidelines then require identifying the economically significant risks that would be assumed by the enterprises if they were acting as independent enterprises at arm's length. Given that the separate entity approach has already severed the group connection, it follows that economically significant characteristics that exist only as a result of the group connection, e.g. lack of credit risk, cannot be taken into account. Now, my submission is that this idea that you're severing the group connection goes too far. Clearly, you're severing the relationship between the two persons. But in any event, we know from the guidelines that you can take account of the group connection in looking at the reality. We've seen that in the guidelines. Of course, you're told to ignore the special relationship between the two persons to the transaction, but you're not told to do anything else, and therefore, in this case, you're not told to ignore the actual understanding that existed between LLC 5 and the other members of the group, that it would receive the sufficient dividends to meet its legal obligations. So what HMRC seem to be saying is not that importing third-party covenants leads to a different economic transaction. That was the Upper Tribunal's decision. But it materially alters the economically relevant characteristics. That was its decision. HMRC aren't saying that now. They're saying, in postulating the arm's length transaction, you've got to get rid of some actual facts in the real world, like the fact that there was no actual credit risk being run, because that's as a result of the group connection. Now, that is a totally different argument from the one that the Upper Tribunal thought was correct, and in my submission is equally wrong, because, as we've seen from the guidelines, and indeed the legislation, which tells you to take account of all relevant factors apart from certain things, that you don't abandon the reality that there was no credit risk, albeit that that was as a result of a group understanding. So I think those may be enough for this morning, and then I'll return to unallowable purposes after the short adjournment, if I may.
Thank you very much. 2 o'clock.